The
Yeah,
June 24th, 2014 meeting of Public Safety and Legal Administration Committee has now come together and convened. This is the regular committee meeting. To my right is Councilperson Yolanda Adrians, Councilperson Kwanzaa Hall, Councilperson Michael Bond. That constitutes a quorum, and we're now called to order. The chair will entertain a motion to adopt the agenda.
so move.
It's been moved. Let's see, any discussion?
Councilmember Mark, we need to amend your
Add the walking
agenda,
paper.
add one resolution. Yes, sir.
Yes. It's in front of you there.
Thank you, sir.
What is the number on that? Is there a number on it, Al?
No, sir, because of Elms, we haven't numbered it as of yet, and we'll
Okay,
get a number,
all right.
but no, sir.
Okay. So the agenda is adopted with the walk-in paper. Next is approval of the minutes, and we approve the adoption of the agenda, yes. Now, we're dealing with the minutes. If there are no admissions, deletions, or chair will entertain a motion on the minutes. Okay, it's been moved and accepted. Are there any additions? Hearing none, no more discussion. Hearing none, all those in favor, let it be known by saying aye. Opposed, let the record show that it passed. And we've now been joined by Councilperson and Vice Chair Keisha Bottoms, and we've been also joined by Councilperson Mary Norwood. On the presentations, I would raise the question on the code enforcement update. Do the code enforcement people have a written update? You want to come to the mic?
We're still continuing on with our 311 rollout. We have still monitoring our cases for service level agreement time, which is the number of cases that we have that are currently open that are under the required time limit. And we're up to 82% on that, and our goal is 90%. We still are continuing with our collaborative meetings every 2 weeks where we meet with other zoning departments, Washington, we are continuing to send our properties that we have a hard time getting owners to cut. We have abandoned properties. We're still sending those to public works. We provide some information about that in our last meeting.
The demolition orders, we're currently up to 260 demolition orders. We are currently in the process of prioritizing all the properties that we have. So the burned structures, the structures that have been on our list the longest, properties near schools, those are the ones that are getting, of the orders that we do have, we are prioritizing them. So when the funds become available for demolition, we'll be able to kind of proceed in an orderly fashion, depending on how bad the properties are. I think that's the basic update from that has maybe that has what has changed since the 2 weeks ago. Unless there's any other questions.
I have any questions? No other questions. Just an announcement that in the budget we did pay and give some attention to this whole question. So for public consumption, hopefully they will see some improvements. Alrighty, on the public Public Safety Quarterly Review. I believe there was two that are under consideration to be here today. That was solicitor and public defenders were supposed to be, and I do not see either one at this point, so we'll go ahead and try to get through. On the claims, shall entertain a motion. Okay, the motion has been to approve the claims. Any discussion? Hearing none, all those in favor, let it be known by saying aye. Aye. Opposed, let the record show that the claims were approved. We are now at the regular ordinance for second read. Mr. Berry, would you read those?
Favorable and unfavorable.
Yes, ma'am, they're all considered agenda as one. I'm sorry. 14-0-1336 is an ordinance by Councilmember Keisha Lance Bottoms, amending the City of Atlanta Code of Ordinances, adding Section 62-48 to Part 2, Chapter 62 Courts, Article 2, Municipal Court, Division 1 of the City of Atlanta Code of Ordinances for the purpose of establishing municipal court hours of operation and for other purposes.
Would you take that, since they run together, would you take the next one? 1337.
Yes, sir. 14-0-1337 is an ordinance by Councilmember Keisha Lance Bottoms to amend the Charter of the City of Atlanta, Georgia, adopted under and by virtue of the authority of the Municipal Home Rule Act of 1965, OCGA, Section 36-35-1. It's, what is that word? Whatever the term is, as amended, so as to amend the Charter of the City of Atlanta, Georgia, 1996, Georgia laws, page 4469, by amending Subpart A, Article 4, Courts, Section 4-104G and 4-105B of the City of Atlanta Code of Ordinances for the purpose of modifying judge compensation and chief judge duties, and for the purposes, Councilmember, Public Safety Committee, this paper needs to be advertised for a public hearing, and there's a charter amendment, and we need to hold 1336 while we advertise 1337 for the public hearing.
All right, I believe that there's a motion that the author is going to make in regards to these two papers.
So there will be a motion to hold so that it can follow the appropriate legislative process, but in the interim, I just ask, along with the chair, that we schedule a work session for both of these papers to be discussed. Let me ask you this, so as we schedule the work session, just from a procedure standpoint, should it be in conjunction with the public hearing, or what's your pleasure for that, Ms.?
No, that we do the work session, because we got to find a date, and we don't know when that date may be, so we'll find a date for the work session, and then we'll get back in the order of moving the papers.
So can we, let me just make sure I understand. So in the interim, will we advertise the papers at the same time that we are scheduling the work session? Scheduling the work session will not stop us from advertising the papers. Is that right?
You can or cannot, depending on what the pleasure of the body is.
Well, it would be my pleasure that we go ahead and advertise them as appropriate, and then we schedule the work session as well.
Yes, ma'am. We will have to go ahead and advertise, in that there's a window that we need to meet, so that we will advertise it, so we'll make sure that we do not in any way have this paper outstanding. So it's, is it 45 days, Amber?
Good afternoon, Amber A. Robinson, Senior Assistant City Attorney. I believe it is within 60 days of the initial introduction, which was last Monday, that the advertisement must run for 3 consecutive weeks, and there must be a public hearing, and it has to be within that 60-day window.
Okay. Ms. Adrian had a question.
Adrian?
I have 2 questions. The first question is, if the papers get amended in any way, does that require an additional advertisement and re-advertisement to the public?
Not if the amendments were minor to the point where the overall substance of the matter has not been altered. If the amendments are such that it would cause an alteration of the caption and that the caption would no longer be accurate, then I believe that a re-advertisement would be necessary.
So, for example, in 1337, if there was, I guess this is in modifying judge compensation, say that was changed, the dollar amount or the nature of the amendment, would we have to re-advertise?
As the dollar amount is not set forth in the caption, I do not believe that a change in the actual dollar amount contained in the body of the legislation would require a re-advertisement. But if there was a substitute or an amendment which would require the alteration of the caption, I think is when you would have an issue with a possible need for re-advertisement.
Okay, and this charter amendment doesn't need to go through the NPUs, right? It's just one public hearing here? Is that correct?
One public hearing, that's correct.
So, and so it had a first read on the floor. This is the second read, and it has to have 3.
That's right.
3 reads.
3.
And if we hold it, does that count as a read today?
No, the reads are in full council.
Full council.
So no.
Okay. So the second, okay, so if it's held today, then it won't be read for the second time on July the 7th.
No, it will not.
It would be the following.
If it were to leave the committee.
Okay, gotcha. Okay, thanks. We don't do that this often, and so I wanted to be clear. Thank you.
Welcome.
Now, I have a question before you leave him about the G and the whole compensation issue, period. I thought that was, the judge's compensation was supposed to be tied into the Superior Court judges.
Councilmember Martin, there is no state statute that sets forth that a municipal court judge's compensation be tied to any other court's compensation, and actually, specifically, it gives the governing body of a municipality the power to set the compensation for a municipal court judge.
All right. Ms. Bottoms.
And I won't get too much into detail because we will have a work session on it. But if there's someone, and I don't know if it's you, Councilman Martin, or someone who's been around just for any length of time who maybe can even help provide a historical context as to why we've even set up the court and set up the compensation the way that we have. Because as I read the chart, it seems like we have unnecessarily tied our hands in terms of their structure and their compensation. But we'll get into more detail, but in the interim, if anyone has any information that can help us with that historical context, I'd appreciate it.
All righty. Moving to 1338.
1338 is an ordinance by Councilmember Michael J. Bond to amend the Code of Ordinances of the City of Atlanta, Georgia, Chapter 162, Article 2, Division 2, Section 162-61, entitled Number Limited costs so as to temporarily increase the permissible age of a vehicle that may be operated as a taxi cab in the city from 8 to 10 years, effective July 15, 2014, and expiring on December 31st, 2014, and for other purposes.
All right, what is the pleasure of the body?
Move approval.
Okay, there's a motion to approve. There's a question by Ms. Adrian.
So, Mr. Bond, good afternoon, Mr. Bond. So you just want to do this for the balance of this year, is that correct?
Yes, ma'am.
And then, so you must have a plan in the interim to work on something?
Well, my understanding is that the administration and the affected industry have been working to create an ordinance, a permanent ordinance, over the last 3 years. It was supposed to have been completed by June 30th of this year. It is not. So to give them more extra time, just extending the deadline out to the end of the year, I believe that they're all supposed to have it all worked out.
Well, I appreciate that. I just believe this conversation started, didn't it start in 2009, right?
Yeah,
It started in 2010. It started a long time. Yeah, I was in the Public Safety Committee in 2010, and we were having this conversation. And the goal was to have newer, fresher cabs. And so why are we 4 years out, not at a stage where we have something?
David Bennett, Office of the Mayor. So the conversation, our group started in 2011. There have been a couple of sort of issues that have come up that have slowed that down. The most recent one actually was the change in the industry where the outside parties have come in with Uber, Lyft, and the like, who changed sort of the basis of the industry. That was not something that we really anticipated when we started. As at present, the language that we have prepared is actually in the law department being drafted, and I think Amber would tell you that it's due back to us within 10 days or so. And so the reform that we had proposed is done. It's just a matter of getting it written up and then bringing it back to everybody to review. And so that should happen in the near future, very near future.
So in the next 60 days?
I'd certainly imagine so.
Thank you, Mr. Bennett.
Yes.
We've been joined by Councilperson Cleta Winslow. There's a motion to approve. Is there any more discussion? If not, all those in favor, let it be known by saying aye.
Aye.
Aye. So, Mr. Bond, are you planning to vote?
Aye.
Any opposed? Hearing none, all in favor, let it be known by saying aye.
Aye.
All right, it's 4 people who have approved. 5 people that have approved. Okay, next.
Resolutions 14R3791, the resolution by Public Safety and Legal Administration Committee authorizing settlement of all claims against the City of Atlanta in the case of Sewell Carpenter versus City of Atlanta, civil action file number 12EB015543C, pending in Fulton County State Court in the amount of $62,500, the settlement amount, authorizing the settlement amount to be charged to and paid from Fund 1001, General Fund, Center Number 200101, non-departmental, account 521-2005, litigation expenses, and functional activity number 1512000, accounting, authorizing Chief Financial Officer to distribute the settlement amount and for other purposes.
What is your pleasure? Move approval. Motion to approve. Discussion. Hearing any. All those in favor, let it know by saying aye.
Aye.
Approve. Next.
14R3792 is a resolution by Public Safety and Legal Administration Committee authorizing the settlement of all claims against the City of Atlanta in the case of Kimberlyn Shaw Mallory versus City of Atlanta, civil action file number 13CV227731, pending in Fulton County Superior Court in the amount of $38,000, the settlement amount, authorizing settlement amount to be charged to and paid from Fund 1001, General Fund, Center Number 200101, non-departmental, account 5212005, litigation expenses, and functional activity number 1512000, accounting, authorizing the Chief Financial Officer to distribute the settlement amount and for other purposes.
What is your pleasure? There is a motion to approve. All those in favor, let it know by saying aye.
Aye.
Opposed, let the record show that 92 was approved.
14R 3793, a resolution by Public Safety and Legal Administration Committee authorizing settlement of all claims against the City of Atlanta in the case of Hester Lee versus City of Atlanta. Civil action file number 14MS003468, pending in Fulton County Magistrate Court in the amount of $6,000, the settlement amount, authorizing the settlement amount to be charged to and paid from Fund 1001, General Fund, Center Number 200101, non-departmental, account 5212005, litigation expenses, and functional activity number 1512000, accounting, authorizing Chief Financial Officer to distribute the settlement amount and for other purposes.
What is your pleasure? There's a motion to approve. All those in favor, let it know by saying aye.
Aye.
Opposed, let the record show that they were approved. 3793.
14R 3794 is a resolution by Public Safety and Legal Administration Committee authorizing settlement of all claims against the City of Atlanta in the case of State Farm Mutual Automobile Insurance Company, ASO, Gary Sullivan versus City of Atlanta, civil action file number 2014-EV000800D, pending in Fulton County State Court in the amount of $1,326.62, the settlement amount, authorizing the settlement amount to be charged to and paid from Fund 1001, General Fund, Center Number 200101, non-departmental, account 5212005, litigation expenses, and functional activity number 1512000, accounting, authorizing Chief Financial Officer to distribute the settlement amount and for other purposes.
Your pleasure. The motion to approve. Discussion. Hearing none, all those in favor, let it be known by saying aye. Aye. Opposed, let the record show that they were approved. 3794. That completes the, well, we got to do that paper that was a walk-in.
Understanding that Councilmember Dickerson would like to move his paper on the Hill 14-0-1305, move it forward, no recommendation.
Yeah, which one is
Item number 5 on the Hill, 14-0-1305. Did you want me to sound it? Did you want me to sound it?
Yes.
Okay. 14-0-1305 is an ordinance by Councilmember Andre Dickens to amend Chapter 10, Article 2, Section 10-92B of the City of Atlanta Code of Ordinances so as to provide an exemption from the distance requirement for stores licensed to sell malt beverages and/or wine by the package listed in Section 10-88.1 of the Atlanta Code of Ordinances for retail stores located at 2018 Bolton Road and for other purposes.
All right. Ms. Amber.
This is Amber A. Robinson, Senior Assistant City Attorney. This is an amendment to 1092B, which contains the distance requirement exemptions for package stores in the city of Atlanta. We believe that there are some amendments that need to be made to this piece of legislation, but have no objection to it going forward with no recommendation. We will have those amendments to the committee to the council before full council votes.
What is the nature of the amendments?
more clearly define the rationale for the exemption and to properly number the exemption contained in 1092B.
Good afternoon. Would this apply to the entire city?
No, this would be a location-specific exemption. The exemptions contained in 1092B, and there are several, are all location-specific. Each number under B, 1 through, I believe, 13 at this point, are a list of specific locations by meets and bounds in the city, whereby the council has decided that due to economic development purposes, mostly that the distance requirement should not apply to those particular locations.
So, wait, so this one is just for a store at 2018 Bolton Road, is that right? Oh. And is that District 9, and do we know how the council member in District 9 feels about this?
I apologize, Councilmember Adrian. I believe that question will need to be directed to the author.
Well, the author's not here, and the council rep, district rep is not here. Mr. Dickerson is at large. So I'm going to recommend that we have a choice. We send this on by Monday. The district council person can give their opinion.
Well, but Mr. Chair, if we leave it in held, if the council member affected wanted to pull it off of held on the floor, they had that option as well, correct?
That's correct.
So I think we should just hold it until we hear from the council member.
All right, we have a motion to hold. Any discussion? Hearing none.
But leave it in hold, I guess.
We will keep the paper in hold and advise the author of the choice of bringing it up at the council.
Thank you, Mr. Chair.
Okay. So, I do not see anyone here.
Yeah, Mr. Emmer is going to tell Mr. Dickens.
No, I'm saying I don't see anybody here. I'm going back to the presentations. I don't see anybody here from public safety.
Mr. Martin,
Solicitor or public defender's office.
so we still need to do that one paper that is item 9 on your agenda.
Oh, okay. All right. You want to read it, please?
Yes, sir. A resolution by Public Safety and Legal Administration Committee, a resolution authorizing the mayor or his designee to enter into a memorandum of agreement, MOA, on behalf of the Atlanta Police Department with Hartsfield-Jackson Atlanta National Airport for the use of a vacant paid parking area for the Atlanta Police Department's emergency vehicle operations course training for a period of 5 years on an initial rent amount to be calculated at 40 cents per square foot, $67,811.46, which shall be paid in 12 equal monthly installments, and to be subject to a 6% increase every 2 years following the date of execution, to be charged to and paid from accounts listed below and for other purposes.
It's a pleasure. We have a motion to approve. Any discussion? Hearing none, all those in favor, let it be known by saying aye.
Aye.
Opposed? Let the record show that a paper that has no number to it, but the one that was read, that we have voted on, it has a number now? Is that, you going to read the number, Al?
Yes, sir. 14R3809.
That is the paper that the vote was taken on and passed. Is that correct? We took the vote?
Yes, sir.
That's the end of the business?
Yes, sir.
Mr. Chair, I'm so sorry I missed the briefing this afternoon, but I understand there was a discussion about cry wolf, And while I know we've still got some kinks to work out, I would like to get a presentation from those in the administration in charge of this program on the number of people enrolled and so forth compared to what we expected, and whether they're in a posture to measure the impact on 911 calls. I have a feeling that the enrollment numbers are shy of what they expected, and I just think that we need to start talking about this. So if we could, in the next cycle or two, get a presentation on enrollment and efforts.
Okay, I want to remind the public that Mr. Hall is back in our midst, and in regards to your concerns, in the discussion, Mr. Berry, do you remember precisely how we said we were going to handle this? The cry wolf piece.
First, we're going to reach out to Miss Emily Love just to see what the numbers are. I think Ms. Norwood mentioned about the number of fines. We're going to see the number of dollars, and then try to get with her to see when can we set up a meeting for a work session for the committee.
The question becomes whether or not it's a work session or a presentation. What you're asking for is a presentation on camera. What Mr. Martin had been talking about was a work session. Makes no difference to me which way we go, but
Yeah, it doesn't make any sense to me either, but I do want to, I want to hear about enrollment, because I'm not sure how many people are enrolled versus what they anticipated, the method of communication, et cetera. I'm getting nothing but complaints.
and I have as well.
I believe we have
Yes, Katrina Taylor Parks, Deputy Chief of Staff. Just a question for clarification purposes. Are we talking about the legislation that has previously passed, or are we talking about a work session based on no legislation?
previously
For
passed.
the previous, okay, so we're going to go back and, because I guess my question is, Ms. Norwood, I didn't know whether or not, and Al, you can correct me, or the law department, I didn't know whether or not we could actually have a work session when there's no legislation before the body. A work session, I mean, just on a subject matter, I didn't know, I'm just asking.
In the famous words of some council members, we do kind of a lot of things that we want to do. Yeah, we can have a discussion on any matter that has been,
work session,
that is may come, or,
And so my point, thank you for that, but my point for asking is to make sure that we provide any updated materials and numbers, as you mentioned, associated with that, because it has been a while, so I didn't know whether or not there was new information, or whether or not the discussion, not the work session, was going to be on, future, what's your pleasure?
well, it's primarily the concern was there were council people that are hearing about it. It's been in place long enough now that we are beginning to get some feedback. And so, based on the feedback, I think people just wanted some status, some statistical information.
So we need updates.
And if you get that update, then that would determine whether or not we need to have a work session, because we don't have anything right now to put our hands around, except a few, phone calls here and there that have come in. And it seems that a lot of council people have gotten calls, and it seems that some of it also were people who did not witness, did not follow this when it was in the discussion session, when it was being legislated.
Ms. Parks, I mean, I'm interested in, whether this program is working as it was billed to council. And so some of the indicators are how many people enrolled versus what you planned. Has there been a change in 911 calls? And then, of course, there's the whole fine structure and complaints and so on that might warrant revisiting. But I think we rolled this thing out in the fall with final sign-up sometime in February. So it's been, it's been operating about, 8, 9 months. So there should be some hard data.
Only 4.
Well, we had a deadline that people were supposed to sign up by February. And I want to know how many people signed up versus what you planned on, and what the vendor's doing about all this, because I've got community members who say they've never heard of the program. People don't read their water bill inserts, and there are dozens of alarm company providers, and I don't know, the one I have is a little mom and pop shop. I don't even know if they got reached out to. I have no idea. So I just, it might be a good idea to have the vendor here.
No, and we will provide all of the information you requested, the vendor, all of the stakeholders involved to get the information. That was my point. I just needed some clarity, moving forward. I'm sorry.
And I would just want to add, if I may, Mr. Martin, there's an issue with the fact that if someone is, quote, caught and they didn't know that it existed, they have to pay the fine. I investigated this on behalf of several constituents, and I had to write them and just say, I am so sorry, there's absolutely nothing I can do. But in doing that, in doing the investigation, there are a lot of fines out there that have been assessed, but they haven't been collected. So at best, it is capricious, because tag, you're it, and everybody else is not paying the fines. And so there needs to be a rethinking. I think when you, no matter how much we think we've told them, if they don't think they've been told, it's very difficult to explain to them that they were supposed to have paid more attention. That's just it's a very difficult concept for a citizen to understand. So we need to look at how many fines have been assessed, how many fines have been collected, what are those stats, so that we can make a legislative change if we think that one is warranted.
Right.
So it's a presentation. I would request a presentation to this committee with the being on camera, so any citizen can see the presentation and see what is going on.
Okay.
And any council person that has had any inquiries, it would be good if they would inform them that this report will and should be ready for the next committee meeting, which will be when now? July 15th is a date when there will be some information before this body.
Okay, so is that what we're saying, the presentation and discussion will be on July 15th? Okay. All right, thank you.
On the 15th, do y'all want the vendor here on the 15th?
I think we should.
All right, and so, this just before we go on recess, you said? All right. And we've concluded that the public safety quarterly reviews will be at that next date. That's public defenders. Next on our agenda for the day is Public Safety Legal Administration Committee public comment. The first person is Mr. Willie Brown. As he come up, I want to ask Mr. Hall, have you been able to give Mr. Brown any assistance on his endeavors?
Well, I've tried, but it seems like he wants to take things to a legal approach, which of course we can't go into. I'm still open to meeting, but we talk pretty much every time we see each other about it. But he feels he is due reparations for the time that he's had the pain that he's been enduring as a vendor, and I don't know if there's something that the city can do in that case. He said you had a solution potentially, but
But you have talked with him?
We have talked, yes, multiple times.
Mr. Martin, I resurrect make the comment after the city come up and say what they're supposed to say about the vendor's attorney fee?
Sir?
I'd rather wait till the city come up and say what they're going to say about the vendor's attorney fee.
Okay.
It's on your agenda, it's about the attorney fee of vendors, so I need to know what they're going to do about that before I make my comment.
All right, Miss, you're going to say after we listen to this gentleman who has a question about his constitutional rights, we have Mr. Larry Miller want to talk about the vending, and so I will now ask Mr. Blocker if he will come forward, if he's here. Now, it is my understanding you have been in conversation with the city attorney. Is that correct, Em? No.
Well,
now let the city attorney explain what he cares to explain.
Amber A. Robinson, Senior Assistant City Attorney. As I advised, Mr. Blocker has 2 active claims with the Law Department's claims unit. They're being actively investigated, and the claims unit is in contact with Mr. Blocker.
All right. Did you advise him, have you spoken to him at all?
I personally spoke with Mr. Blocker after the meeting last public safety meeting 2 weeks ago, advised him of his claims, and advised him as to who to contact to begin the expungement process.
Right. Thank you. Yes, sir, Mr. Blocker.
I'm coming back. Just wanted to speak on the whole again because it's been almost 2 years now since these crimes were committed and the investigation started, and yet, it's still under investigation, and to me it's kind of an insult to sit here and state that it takes 2 years to investigate whether an arrest for sitting in a chair watching a game of chess was a violation of my constitutional rights. And I come here with 2 other gentlemen that were on a daily basis part of this deprivation that we suffered under orders for David Waddell, claiming that, at a park in the year 2012, no more than 2 people could sit at a table, and if a third person sits down and there is no compliance with a rule that's not a violation of a city ordinance nor state law, the entire section of the park had to be shut down. It don't take 2 years to investigate that. It's an insult. Okay? The courts recognize within a day, sometime 2 days, that the arrest was illegal, the allegations are weak, and it wasn't even worth, police time and power. Not to mention the fact that it was an off-duty officer who was leading the deprivation alongside the Atlanta Downtown Improvement District just to keep us under the illusion that they had police authority. So it escalated to, well, if y'all don't comply, everybody's going to suffer. So there were days in the summer that we were sitting on a hot ground trying to enjoy public property, playing chess. Now, y'all saying the investigation is still ongoing, but just in my claims alone, I think it was November 26th, December 2nd, they said no violations occurred on August 15th, 2012, and that was the day that I sent y'all the notice. I didn't complain. None of these men, none of us complained about any deprivation that happened on the 15th. It's an insult, and it appears to be a cover-up. And I'm definitely just, when it comes to the fact that Mr. Waddell conspired to send me to prison for 20 years by trying to get Kenneth Thomas to write a police report stating that I threatened him and Oliver Hillman when my alleged crime was, again, sitting in a chair watching a game of chess. But he gets to keep his job. I've lost jobs behind just standing up for my rights, trying to protect people who didn't know what their rights were. And because I had, been in the law library studying law, I knew what was law and what was not law. I knew what was right and what was wrong. So to stand up for my rights, it just seems like that is prohibited in Georgia. It seems like, because it don't take 2 years to investigate. Sitting in a chair watching a game of chess is not a violation of the law. It don't take 2 years to investigate that. It don't take 2 years to find out that putting men on the ground when they were enjoying public property, just trying to have a good time, that was our crime, playing chess. That was our crime, according to David Waddell. It takes 2 years, for real. It took the courts 2-3 days. This man had no business being arrested. It took the Atlanta Citizen Review Board 1 month. And I know I did I submitted a detailed letter on a daily basis, because I recorded everything on a daily basis, whether it was audio, video, or just from memory.
Are you Mr. Blocker?
I'm Mr. Blocker.
So if you refer to this man, are you talking about somebody else?
Well, I mean, I did, you know, and the first grievance that I doctored, that we all signed, went to Councilman Kwanzaa Hall. A copy went to Mayor Kasim Reed and the city's attorney. The very same letter, the very same evidence, so that everybody could be on the same page. Just submitting facts. You find something wrong with the facts, then, you know, deny our rights. But if we are citizens of the United States and we have constitutional rights, what do we have to do to activate them? It don't take 2 years to find protection. You didn't take 2 years in the Atlanta Eagle raid. There was a boss raid on another restaurant where citizens was sitting in the chair, and, you know, the police officers went in there and ran their ID. That was found to be a violation of their rights. It took a year. The woman that was falsely arrested and sat in jail for 53 days, it took a year. And even under that Calhoun versus Pennington case that was in federal court, it was found that internal affairs investigations, sometimes they take on the illusion of an investigation, 2 years. So that's why they mandated 180 days, tops. It's in the standard operating procedure.
So what you're telling us is that you filed a claim, and it's in our claim division of the law department.
Well,
and it's been more than 2 years, and you haven't gotten a response.
No, actually, this was the statement last week. No, the claim was denied, stating that, and I have a copy of it, stating that there was no deprivation on August 15, 2012, and I didn't complain of a deprivation on August 15th. That's the day I sent it to you, certified mail.
So
I have a copy of it.
If a claim has been denied, it means it's been through here? Is that what you're saying? It was denied in our claims division, and it never got here? Is that what you're saying? Is that what you're saying?
Well, on the count, yeah, I have Department of Law Claim Investigation Summary.
You want to pass that down?
Yes, sir.
Ms. Amber?
And I'm also going to pass you the Citizen Review Board statement of the actual dates that was in question. August 15th was not a date in question.
Okay. This claim that you sent us, this paperwork, is going to say that your claim was denied. And now,
based on a date that that wasn't even a part of the investigation.
So
the actual content of the allegations were not defeated. They weren't even addressed. They talked about another date. That was the day I sent it to you, certified mail. And if I had my records, I got off work. But if I had my records, I could show it to you. I still have the copy. I put it in the mail on August 15th.
Oh, what year? 2012? Okay. And I guess I'm asking Kwanzaa, does that paperwork there say when we approved the denial?
Yeah, I'm trying to read.
That first document that he's reading is from the Atlanta Citizen Review Board, and it was just based on the dates that were in question, as far as my arrest. But then we still have dates, again, that was in the allegation. It was supposed to be an overall investigation, not just of what occurred as far as me being falsely arrested, but the crimes that me, my friends, and my associates also suffered. okay? Because again, we have grown men being treated like we were in prison. Sit up. Stand up. You can't sit down in a park and have fun. You can't eat in this section. They used to tell us we couldn't eat. I don't believe slaves was handled like that. I don't believe during segregation men were handled like that. You can't eat in a park.
Okay, but let's try to get to the part of this that is before us now that you are saying, and we're trying to hear it to get some clarity on it, to know, deal with some dates that were involved, because you mentioned 2 years. In other words, what I've heard so far, and I want to make sure that I'm right, is that 2 years ago, you were arrested.
Falsely arrested.
Falsely arrested. And you went before a judge, and are you saying that they threw it out?
The cases were dismissed sometimes the next morning in 1 or 2 cases. In one case, 2 days. In the third case...
So you're fighting somebody else's battle other than yours?
No, sir, I'm just speaking out.
I want to know what happened in your case.
Sir?
I know what happened in your case.
Okay, in my case, in one case...
But you're the one that's here before us.
Yes, sir. Yes, sir. But they also signed the first grievance because they were victims too.
But they didn't have to go to court, did they?
No, sir. No. Okay.
Let's deal with you, because
yes,
what's before us is you and our claims division has treated you
unjustly.
Oh, you didn't answer my question, so I'm asking Mr. Bond.
I saw there are 3 documents here, and one...
is the claim.
One is a
copy of a claim where we, the council, approved the denial of Mr. Blocker's claim.
And that was dated 10/30/13, and then by the city attorney on 11/1/13. The claim original date was October 25th, 2013, and it is listed as adverse for that date.
Well, that's the recommendation.
That's the recommendation.
There
It
is
doesn't show anything
no
else.
council action on this document.
There's not been any council action?
Not according to this document. It's blank.
Yeah, it's blank. There's another document.
What does that mean?
It's September 12th.
Well, that is
2012. Yeah, that's all. It's only 3 documents. The one from the Civilian
That's the
Review Board.
recommendation form and tracking form of the progress of the claim from the law department. And it has on the bottom, there's the recommendation. Their recommendation was to adverse your claim. Then it has the list of, I guess, the checkoffs of where that recommendation has to be, I guess, finalized. And there's a blank, there's a recommendation there for council action, and the council action section of that is unmarked. It's blank.
Which means it hasn't been before this board.
Well, according to that copy of the document, it has not been before the council.
But it might be worthwhile for Mr.
But we have
Berry
to
to
go
search.
back, Mr. Berry and our staff should search and see if they have it. But I see Frederica's got her hand up, Mr. Chair. You have to do it on the mic, though.
These are not the form that gets to us looks a bit different from these.
So that's what I was...
When it comes to us, just hold a minute,
Sir.
Mr. Parker, please. Let me deal with it. What comes before us, looks like this. And so that's why we are going to have to, you'll pass him a copy of that so he can see that. That's what comes for us. And so apparently it didn't get to,
We got here in December. That's what,
it did?
yeah, and that it was acted on in December.
Where
That it was
is
acted
the-
on in December, but he's going to print it off, so
Oh, okay.
he's going to bring the documents in here to the committee.
So it did get before us, and we approve the adverse.
Right.
next step would be, I believe, would be for you to,
But do you understand, first and foremost, the reason of my complaint? If you say that there was no civil rights violations that occurred on August 15, 2012, and that was the reason that this council denied the claim, and there was no claim for August 15th, you didn't even review the substance of my complaint. You didn't defeat it to deny me anything, nor my friends nor associates. Okay? As a matter of fact, the Atlanta Citizen Review Board has now concluded on 3 of the 6 arrests, and they said all 3 were illegal, and recognized that this was a system of profiling, and like I said in the letter, because I stood up for my rights, it was prohibited. So to intimidate me, to keep me quiet, they continue to arrest me and make up these allegations, and all of them were unfounded. That's why the court dismissed them all.
okay, now, the sheet that I'm looking at now that has the October 25th, 13 on it says, major claim. The claimant alleged his civil rights were violated when he was arrested. The investigation
On August 15th.
determined,
I was never arrested on August 15th.
no, this doesn't say, what I'm reading doesn't have that date. What I'm reading says that the claim alleged his civil rights were violated when he was arrested. The investigation determined the claimant has failed to provide sufficient information to sustain his claim. That's what this document says.
So it's on the internet. I mean, I pulled it off the internet. It says specifically August 15th. It said August 15th.
Mr. Martin, I've been advised that August 15th was the day it was filed, not the day the incident happened.
That's right.
But all I'm dealing with in terms of this document is the day that we dealt with it, that it got to us, or the date when he filed it, and then I don't know exactly, I don't show when it got to us. Do anybody know what date we
I think that's what Mr. Barry, that's what Mr.
they're going to get that?
Excuse me. May I please see it, Mr. Parton? May I please see it?
See what?
The documents I just turned over.
I just, and maybe Law can answer this. I see the bodily injury amount. Is this, I don't know if this is a typo, is this 68 million?
Actually, that was a claim based on multiple causes of actions for over 30 people.
So was that total was 68 million? I'm just wondering if that's why.
I don't know. I mean, when you file a civil claim, you can put whatever number you want to put on it. But right here it says date of occurrence. Date of occurrence, 8/15/12.
No, but what I'm trying to get Law to answer, maybe this is something that you all will have to discuss with us out of the presence of the parties, but when you all track your claim, will it say you all will have a reason for denying that claim? So can you tell us why it was denied? Was it not substantiated? Were you not able to negotiate a favorable settlement, or what?
Councilmember Bottoms, we'll be happy to prepare some information for this committee regarding the details of his former claims, any current claims he has, as well as any complaints that he has filed with the Atlanta Police Department's Office of Professional Standards, as well as the Citizens Review Board. At this time, I do not have that information, but we will definitely get that to you as soon as possible.
Yeah, it seems, and I'm sorry, Mr. Blocker, for what you're having to endure, but I think it is wise for us to at least give us a week or two for our legal team to give us a final update on what they believe the situation is now. That may not be what council agrees to, but if you could just endure with us for just a little bit longer.
Yes, sir.
And give us a moment to kind of go through all of the documents and kind of maybe even have to have a executive session so we can make sure we understand everything.
And like I said, it's online, it's recorded. The reason that they claim no civil rights violated, and it specifically states in the public record on August 15, 2012, and just like it says on this document, date of occurrence, not date of submitted, date of the alleged occurrence, August 15th. That was the day I mailed it to you, okay? And again, you know, I know I'm not an attorney, but I am a man. I have friends, and I'm concerned about their situation too, and they suffer just like I suffered.
Mr. Martin. Now, okay, so I'm just looking at a different document here, and I'll give you a copy of it, Mr. Blocker. This one has a date of occurrence is May 10th, 13.
That was
so this isn't that's not the one I saw on your document. It had a
that
different
didn't happen
date.
in the park. That didn't happen in the park, but that case was also dismissed, and the Atlanta Citizen Review Board came back and said that was illegal too.
Okay, so we're not, Mr. Berry, it's another document that we need to look at, not this document.
Well, we have three. We have 3807, we have 3810,
But there are other
and we have
claims,
3811.
but they're from other individuals.
Well, but they all COD blocker.
Right.
Okay.
Because
Even one of the gentlemen standing there named, last name is Bay, the last name is Yonker.
Nelson Bay? No, sir.
Okay.
No, sir. I couldn't get into
Yours is one that's 3807, and this committee voted adverse on 11/26/13.
Right. Said that no civil rights violations occurred on August 15th.
Now, let me tell you how this works. These claims are submitted to us, and they either, you know, something that they recommend we approve or we adverse.
Yeah.
We did no investigation, this committee, because we can't do an investigation. We have a division to do that. And when it got to us, it said adverse, and that's what we did. We approved the adverse of your claim on August 26/13. And we also adverse another one on 11/26/13, where apparently there's another person, Carmen Nelson Bay, and Lawrence Yonker. All these were claims that also have your name on them, your address, and they're all, well, this one has a lot more paperwork with it.
Mr. Martin, we're missing
3804. We're going to get that one now.
Well, actually, there's a claim number 12L0641, which is the one that Mr. Blocker gave us, which is different from this document, 13L0591. So there are two that are reflective of other individuals. This one is Mr. Blocker from the 13th, from the date of occurrence is 5/10/13, but what we want to see is the one that's 8/15/12, and it's 12L0641. So maybe one other document out there, Mr. Martin.
So that's what I'm saying. The one that was sent on August 15th was addressing false arrests that occurred on June 1st, June 18th, and July 4th. These dates were not mentioned. It said no civil rights violations that occurred on August 15th. You are addressing August 15th, which means the allegations that I made, submitted with the evidence of the court dismissal, was not even addressed. It was not addressed, and it couldn't be defeated, because if you have a judge that say, well, his constitutional rights was violated, case dismissed, you have a review board that says the arrest is illegal, how do you all come with something different based on the same evidence?
Well, the city attorney said that they would get some more information to us. We don't have, I don't believe, enough information today to get you a satisfactory answer. So, as Mr. Hall said, Mr. Barnwood, give us 2 more weeks and you come back then, because I think one of the issues may be, I don't know, when you have come to this body before now, when the claims people told you whatever they told you, apparently there's nothing that tracks you to us after that until the last meeting of the day. I understand you were here.
Yes, sir.
So where were you all that time? You didn't know that you could file
No, sir.
and come to this body or
I
what?
filed an antelitum notice, but at the same time, because you all have an oath of office and an oath of exit, I didn't need to step up and say anything. I gave you what was necessary to defend myself and my friends, okay? To have these same... Do you know that Officer Thomas, okay, who survived 9 internal affairs investigations because of how internal affairs handled an investigation, is still out there, right? And it just came to me as we were coming in the building. The same officer that falsely arrested me twice, who has a track record of falsely arresting individuals, arrested a guy, put him in handcuffs, a guy that was 150 pounds, and slammed him on his head so hard that he incited the entire park. This man should have been fired and prosecuted a long time ago. He's still out in the park harassing, intimidating, falsely arresting, and abusing citizens. But this felon gets to wear a badge. This criminal gets to wear a badge. And it's documented that he don't know what to do with that badge and that gun, but be a big bully. He should have been prosecuted. Instead, he comes to work, and we have to pay for this man to commit treason against the United States. Instead, he violate the Constitution. We have to pay for this. We have to sit back and watch him.
Okay, are you through?
Yes, sir.
Okay. Again, I believe it's the consensus of this body that we do some investigation into this and get back to you. Do we have all the necessary information to get back in touch with you? Because there's some reading here of these 3 documents and one that we're still waiting to try to see that we will have to look at. It's information that that we didn't have.
They have an adverse based on
We didn't have this information. Well, we got another piece now.
And it's not just not about compensation. Again, other people were protected when the police stepped up and violated the law, and I demand the same thing. I want these same police officers that violated my rights, that violated my friend's rights, I want them prosecuted. Okay?
Well, we don't prosecute people. This committee do not, but we will get you some information.
Okay, this is related, but it's still not the document that Mr. Blocker gave us that has, city signatures on. That's the one I want to see, which is... Can I see his document? Yes. Oh, yeah, I think you have your document, Mr. Blocker. Just so he can...
Not the entire document. This is just the antelitum notice, but the actual allegation, this came offline. But the actual allegation, the 15-page allegation for the first 3 arrests, and the other 2 antelitum notices, I don't have them with me today, but I can send them. Whoever you need me to send them to.
What we would just handle is what we would just handle says the claimant/victim. This is Alfonso Thomas.
Yeah.
Now, all of these have the same, where it says the nature of the claim, they have the same thing.
Yeah, the same. They all claim no civil rights.
Allege his civil rights were violated when he was arrested. The investigation determined the claimant has failed to provide sufficient information to sustain his claim. All these documents say that.
Yeah,
and there's some additional information attached that we will have to have time to read. And as I said, the date that we would like for you to come back is, when is it, Al?
15th.
July 15th.
Yes, sir.
Yeah, if you come back July 15th, we will try to have a response for you. We will have looked at this. We've heard what you had to say, It's videoed. And if your rights have been abridged, we, of course, would be certainly taking that under consideration and would owe you an apology, but at this point, we do not know because we weren't there. We're not a witness.
Well, I have audio and video footage. I have audio and video footage. I have court dismissals. I have pictures. I have whatever you need as evidence.
But meanwhile, I think you ought to consider, if you're not satisfied at this level of, going to the Civil Rights Commission and file a claim.
Civil Rights Commission?
At the federal level.
Okay.
That is what, just from what we have now, that is what I would suggest you, because that's one of your rights. Whether you want to do that or not is up to you, but that is one of your rights. If our process is too slow and you're not satisfied on the 15th, that's what we'll be telling you then. Okay?
Yes, sir.
Okay, hold it, Mr. Bond, want to say something to you.
Thank you, Mr. Chair. I just have a question. Were you ever asked to provide that information?
I did it freely.
No, I'm saying, did they ever inform you during the process that
no, sir,
you needed to submit more information?
There was no communication whatsoever over the past 2 years. Once I submitted it to the respective parties in terms of Councilman Hall, Caesar Mitchell, Kathy Hampton, and then the Atlanta Citizen Review Board. Actually, the complaint to the Atlanta Citizen Review Board sparked the investigation as far as the internal affairs investigation. So I was under the impression that I had submitted it to the proper...
No, well, what I'm asking, though, specifically, those that the folks in the claims department, the law department.
No.
Did they ever ask you...
Contact me? No.
Contact you for any reason, tell you that you had insufficient information for your claim?
No. I think the investigator name was Angela Kelly. I would call to try to get, clarification of where the process was at and what she needed. And she never, disclosed to me that there was anything that was necessary. I didn't even know that a vote was coming down November 22nd and December 2nd. So, no, throughout the 2 years, I thought, again, that I had submitted it to the proper people.
And you say you got audio, video, eyewitness, and all that?
I mean, on a daily basis, we were violated on a daily basis. And it's video, audio, video.
Do you have audio for the specific claim date, though, that you're...
Yes, sir.
You have all that?
Yes, sir.
Okay.
Yes, sir.
Thank you.
So if you need me, who do you need me to send it to? I'd like to get that on the record right now.
We'll determine that on the 15th.
Can we bring it in to you?
No, I think it may be wise to bring it in advance and submit it to the chair and the committee members. I recall the documents, and we spoke a while ago, several years ago, you gave me the documents, but I don't know if I saw the video and that kind of footage.
Yes, sir.
So I think it may be wise to just bring everything submitted to Councilman Martin at worst case, but really to all the committee members.
So maybe a copy for each member?
Yeah. And if it's, if it's too much, to submit one to Councilman Martin, or my office can help you to, present it to us.
Yes, sir.
Okay.
Are we concluded, sir?
Yes, sir.
Thank you for your time.
Okay, Mr. Larry Miller is next. No, Mr. Brown says he wants to talk after Larry Miller. Y'all better make up your mind now.
We're waiting on the presentation that they vote on the city as we need to say.
Wait a minute, what presentation are you talking about?
Well, they said they were going to bring forth what they were going to do about Turnfield.
Miss Parks.
Taylor.
Miss Taylor Parks, do you plan to tell us anything about what you are going to do about Turner Field today? No, they claim they want to hear what you got to say.
Katrina Taylor Parks, Deputy Chief of Staff. We are ready to have a conversation with the vendors regarding Turner Field. We were ready to have that conversation about a week and a half or 2 weeks ago. I'm going to need Amber to come in. Someone filed another legal document that needs to be discussed. Now, how does that play a role? And I need her to tell me the type of it, but what happens is, it may not have been Mr. Miller, it may not have been Mr. Brown, but the claimant or the person that filed it is a vendor, and the outcome of their claim affects this overall decision. So where does that leave us? When I spoke with Amber earlier today, I think that she stated that we feel comfortable that this would be over relatively quickly, and in doing so, then that's when we will sit down with the vendor specifically relative to Turner Field, and start talking about a plan to move forward. But Amber, I couldn't think of the name of the document that was filed.
Good afternoon, Amber A. Robinson, Senior Assistant City Attorney. The matter of Hambrick versus Mayor Reed and Chief Turner is coming to a conclusion, we're happy to say. However, the plaintiff in that matter, which is the matter that concerns the legal ability regarding vending around Turner Field, plaintiff in that matter has filed a motion for reconsideration of the Supreme Court's dismissal of his latest appeal. And so we are currently waiting on a conclusion or decision from the Supreme Court regarding that motion for reconsideration. And at that time, the parameters of our discussion will be defined, and we can move forward and discuss where we are after that time.
Parks. She has now spoken. Ms. Miller heard what was said. Okay. Do you care to respond?
Larry Miller, Turner Field vendor, president of Atlanta Vendors Association. Mr. Martin, under previous conditions of the lawsuits and whatever, I'm not ignoring any lawsuits or anything, no disrespect to them, but there is no apparent reason that the Reed administration have for not putting vendors back to work at Turner Field. No lawsuit stops them from putting our locations back into the ordinance as they was taken out by Mr. Hans Hoot during the time that he was negotiating with the Braves. Our locations should have been put back into the ordinance as well as the rest. Now, we sit here and watch people blow smoke, but we're not going for that. I mean, you know, what is stopping this administration from putting locations back at Turner Field? It is not the lawsuit. It is the city ordinance. The city ordinance had those locations there. They've been there for 27 years. And when they rewrote the ordinance, they just took them out. Now they just need to put them back in. And when they put them back in, this case is closed. It's just that simple. Now, if they want to reach out to the attorney, as I suggested, I've left messages. I've tried to communicate with the attorneys and told them that all they had to do was reach out to the attorneys. Reach out and touch. That's all they have to do. Because our only concern is about going back to work, not trying to litigate and fight and fuss and bicker. Our families need us back at work where we could make, we're losing 80% of our business over a year and a half now. And if people just want us to sit around and sit on our hands and do nothing, there is, I can't, why wasn't the, okay, we sit here, how many locations have you guys passed since the year and a half on a failed vending project that we already have agreed that is a failed vending project? But the most successful vendors in the city of Atlanta who directly impact tourism are put out of business. Something's wrong with that picture. Maybe it's because we are black. Black and white, you know, whatever. But we're not at work. And we've been out of work over a year and a half for no apparent reason. For no apparent reason. So my question is, why can't the locations at Turner Field be put back in place like they should have been when the ordinance was rewritten? And it has nothing to do with a lawsuit. Nothing. That's just smoke. Nothing to do with a lawsuit. All they had to do is reach out and touch. That's all they have to do, make one phone call, and it's over.
Mr. Brown.
Well, Mr. Martin, this is my badge from 1994. When the city said, the law department said that I was never a vendor, so I was subordinate to somebody else. But my permit said I was 19, let me see, expires 3/29/1995, space 610, Turner Field. Now, it's just like what you said just a while ago when that man come up here. You said, where have you been since your claim was denied? For the last 12 years, 2 or 3 years, I've been standing there fighting for my rights. So I'm just have to wait until the city do what they gonna do about these vendors, where I can come in and have mine, because I have mine right here. Economic development, where the city was supposed to be doing economic development for street vending, never did. They robbed the folks, took the folks. I have a lady now that I have a spot, got a spot, Sweet Auburn New Bread Company. She had one of those kiosks up there. I don't want a kiosk. I don't need to work but 81 days a year. It's nobody but me. I can make enough in 81 to take care of me. So we need to, say July the 15th. Baseball season have about 40 more games, if they have 40 then. So when I go back to work, ain't no money gonna be made. I'm in the hole when the season close up. If I didn't get a chance to turn the money and even make no money, just go out there and stand. So that's where we at. So the city gonna do something on the win. I guess 12 years of slavery.
All right, if there's no one else to speak, that exhausts our list. He'll entertain a motion to adjourn.
So moved.
We are now adjourned. Thank you.